Hi, in this video the Legalraasta team will teach you all about the Private Limited Company as per Companies Act 2013, its definition, minimum requirement and advantages. Definition of Private Limited Company. A quick perusal of the Companies Bill 2013 shows that many exemptions given to private limited companies under Companies Act are withdrawn. The following provisions are applicable to private limited companies under the new Companies Bill 2013. Maximum number of members. There is no change in the minimum number of member, which is 2. The maximum number the members in a private limited company are increased from 50 members to 200 members. Clause 2 subsection 68. Financial year for the balance sheet. Financial year of the balance sheet will be 31st March for all the companies. For any relaxation, approval from NCLT is required. Clause 2 subsection 41. Postal ballot for passing the resolutions. Till now postal ballot is applicable only for listed companies. Postal ballot is applicable to private limited companies also for certain transactions after the amendment prescribed by the central government by notification. Clause 110. Certification for annual return. Annual return must be certified by a practicing company secretary, and requirement of compliance certificate by practicing company secretary is dispensed with. The annual return should contain particulars like a. The extract of the annual return is provided under subsection 3 of Sections 92. B. Number of meetings of the board. C. Director's responsibility statement. D. A statement on declaration given by independent directors under subsection. Number of days of notice of general meetings. For private limited company as per the existing Companies Act is even 7 days notice is sufficient. This exemption is withdrawn. As per the new provisions, 21 clear days notice has to be given to the shareholders, and the notice can be given by electronic mode also. However, the general meeting may be convened by giving shorter notice if consent is given in writing or electronic mode by not less than 99% of the members entitled to vote at such meeting. Clause 101. Corporate social responsibility. Every company having net worth of rupees 500 crores, or more, turnover of rupees 1000 crores, or more, or a net profit of rupees 5 crores, or more during any financial year shall constitute a corporate social responsibility, CSR, committee of board consisting of 3 or more directors, out of which at least 1 director shall be an independent director, and 2% of the average net profits of the immediately preceding 3 financial years should be spent for CSR. Clause 135. Appointment of auditors. An auditor will be appointed in the first annual general meeting for a 5-year term. Thereafter, the auditor will be changed as per the members' decisions. Secondly, an audit firm cannot be reappointed for more than 2 5-year terms. That is 10 years for reappointment purposes for the individual auditor or audit firm. There has to be a gap of 5 years. Moreover, for appointment or reappointment purposes, there should be no common partners between the new firm and old audit firm. Another interesting clause is that members can resolve to ask the audit firm to rotate the audit partner and team every year. Appointment of internal auditor. Such class or classes of companies as may be prescribed shall be required to appoint an internal auditor, who shall either be a chartered accountant or a cost accountant or such other professionals as may be decided by the board. Conduct internal audit of the functions and activities of the company. Clause 138. Duties of directors. A director of a company shall act in good faith in order to promote the object of the company. A director of a company shall exercise his duties with due care, skill and diligence. A director of a company shall not assign his office, and any assignments so made shall be void. If a director of the company contravenes the provisions of this section, such director shall be punishable with fine which shall not be less than rupees 1 lakhs but which may extend to rupees 5 lakhs. Clause 166. Classification of private limited company, loan and investment. The exemption given to private limited company under Section 372A regarding loan and investment is withdrawn. Existing limit of 60% paid-up capital and free reserves or 100% of free reserves applicable to both private limited and public limited companies. Exemption to private limited company for loan and investment under Section 372A is removed now. Clause 186. Loan to directors. The exemption given to the private limited company under Section 295 regarding loan given to director of a private limited of company is withdrawn. Loan should not be given to directors of any company including private limited company or to any private company in which a director is a director or member. Clause 185. Board and Annual General Meeting Minutes. Hereafter the companies shall follow the secretarial standards while making the minutes of Board and General Meeting. Clause 118, 10. Books of accounts. The books of accounts may be kept in electronic form also. Clause 128. Managing Director. The exemption given to private limited company under Section 269 for appointment of managing director is withdrawn. Provision relating to the appointment of managing director is also applicable to the private limited companies. Clause 196. Legalraasta.com is India's top destination for legal and company matters. We can help you informing any type of legal documents and business entity, example private limited company, LLP, filing individual and company return, helping companies for their compliances such as ROC filings and minutes, protecting work through trademark and copyright. We are a trusted partner with multiple top-level expertise and affiliation, and yet cost-effective. So log on now at Legalraasta.com to Private Limited Company as per Companies Act 2013 or mail us at contact@legalraasta.com.